Hello, and thanks to everyone who's joining us today. My name is Maggie Garrett, and I am the Vice President for Public Policy at Americans United. And this is the National Advocacy Summit's panel on the Juneau Harm Act, Fighting for Religious Freedom for All. Today's panel is designed to give you an in-depth look at the Juneau Harm Act, a bill that many of you will be lobbying your members of Congress about tomorrow. The Juneau Harm Act will ensure that the Religious Freedom Restoration Act, or RFRA, which is a federal law that protects religious freedom, is actually used to protect religious exercise and not misused to undermine non-discrimination laws or deny people access to healthcare. Congress adopted RFRA to serve as a shield to protect religious freedom, but sadly, it's now being used, particularly by the Trump administration, as a sword to harm others. The Juneau Harm Act will fix that. In this panel, we're going to examine in more detail what the Juneau Harm Act does, why we need it, and why it's more important than ever that it passes. But for those of you who are lobbying tomorrow, I don't want you to worry about memorizing everything you learn here today. You will be provided with talking points and other information about the bill and about lobbying that is going to be all you're going to need to lobby successfully on this bill. So don't worry too much. So on this panel, we're really, really lucky to have some super smart people coming from multiple organizations that we've been partnering with to support the Juneau Harm Act. So in alphabetical order, we have Layla Abel-Fazli, Director of Federal Reproductive Rights at the National Women's Law Center, Katie Joseph, Director of Policy and Advocacy at Interfaith Alliance, Robin Merrill, Associate Legal Director at the Human Rights Campaign, and Maggie Siddiqui, Director of the Faith and Progressive Policy Initiative at American Progress. But before we get into the discussion with the panelists, I'm going to give you just a little bit of background on RFRA. Because the Juneau Harm Act amends RFRA, we have to do a basic review and get a basic understanding of RFRA before we can really understand what the Juneau Harm Act does. So RFRA was adopted in 1993 in reaction to a 1990 Supreme Court case called Employment Division versus Smith. In Smith, two men, both counselors, were fired by a drug rehabilitation center for taking peyote, a hallucinogen, as part of their religious practice in the Native American church. Both men were then denied unemployment compensation by the government because they were fired for using an illegal drug. So they went to court arguing that the government denied them unemployment, a government benefit, because they engaged in a sacred religious practice. And that violated their religious freedom rights under the Free Exercise Clause of the US Constitution. Justice Scalia, writing for the majority of the court, surprised everyone, not just because he ruled against the Native American counselors, but because he wrote an opinion that seemed to totally change the test the Supreme Court applied in free exercise cases. Justice Scalia said that so long as a law is, quote, neutral and generally applicable, meaning that it applies to everyone equally and it doesn't target religion for worse treatment, there is no free exercise violation under the US Constitution. At the time, people from many faiths and denominations, legal experts, civil liberties advocates on both the right and the left, including Americans United, saw the decision as a drastic change that could weaken constitutional protection for religious freedom, particularly for religious minorities. So they joined together to pass RFRA. RFRA was intended to codify or to put into a federal statute the constitutional test that existed before Smith. Generally, the RFRA test asks whether a law substantially burdens a person's religion. Minimal burdens on religion don't trigger RFRA's protection, or at least they're not supposed to. But if there is a substantial burden, the government must prove it has a compelling interest in enforcing the law, and it is the least restrictive way to achieve that government interest. That's the test we have today. But things didn't turn out as expected. Today, RFRA is frequently being misused to harm other people. In particular, it's been being manipulated to allow discrimination against LGBTQ people and religious minorities and deny people health care. The Trump administration, for example, has used it to allow taxpayer-funded foster care agencies to place religious litmus tests on potential parents and volunteers. It has used it to expand religious exemptions that allow federally funded social service providers to hire and fire employees based on religion. And they've used it to deny workers insurance coverage for birth control. Unfortunately, religious freedom is now becoming synonymous with discrimination. And that is why the passage of the Juneau Harm Act is so important. The Juneau Harm Act is designed to restore RFRA's original intent It will preserve the law's power to protect religious freedom, but also clarify that it may not be used to harm others. And that leads us to our panel discussion. So I'm going to start with you, Maggie. And my first question is, can you tell us the value of religious exemptions, but also why they should be limited by this do no harm principle and how that protects religious freedom?
Sure. Thanks, first of all, for having me on the panel today. And I think that's a really important way to start. It's really important to remember that religious exemptions do have an essential value in protecting our religious freedom. There are times when laws or regulations might result in an individual feeling compelled to have to violate their religion or conscience. And as a nation that values the principle of religious freedom, we absolutely seek to avoid that. So for example, an employer might legally or reasonably expect employees to be available for work on Saturdays, but an employee who observes the Sabbath would seek a reasonable religious exemption from that and expect to be safe from retribution from their employer. An atheist offering testimony before a court of law would reasonably expect not to have to swear an oath on a Bible. Our nation's religious freedom demands that we receive these kinds of reasonable accommodations. However, if those accommodations would then violate the rights or safety of others, there is a compelling government interest in limiting those accommodations. And what we're talking about today is the argument that we hear from some people that their religious freedom is dependent on being able to discriminate against people of different religious beliefs, so to violate the religious freedom of others, that it's dependent on being able to discriminate against LGBTQ people, to violate their civil rights, or to discriminate against people seeking reproductive health care, therefore denying their ability to access health care. So we're seeing this broadening of religious exemptions to include essentially inflicting harm upon others. And that is when there is absolutely a compelling government interest in denying that kind of religious exemption, and where in effect denying a religious exemption would be a safeguard for religious freedom.
That's great, thank you. And I think that most of the groups, including Americans United, who supported RFRA on the left side of the aisle, really thought that that limiting principle would be in there. So after RFRA was passed, it was originally thought that it would apply to the states as well as federal laws. And then there was a Supreme Court decision that said that it only applied to federal laws and not the states. So after that, there was a movement to pass RFRAs across the country in the states. But that really died down, and then we didn't see any of that for a really long time. But then starting around 2013, there was a sudden explosion of RFRA bills in the states. And Robin, I'm hoping that you can explain to us why we suddenly saw this explosion of RFRA bills, how that effort was different, and how it was sort of RFRA was framed differently, and why we're not seeing so many of those bills now.
Yeah, absolutely. If you think about what was happening in 2013 versus 1993 when the federal RFRA was passed, the big thing in the room is we had the Windsor decision in 2013, we had the Obergefell decision in 2015, we had Burwell v. Hobby Lobby in 2014. So this was really a series of cases and social change that I think really sparked among a lot of people an urgency to try to avoid specifically same-sex marriage and the requirements that I think people saw coming down the pike for same-sex couples and LGBTQ people. As you mentioned, this really was, and Maggie, you mentioned that this really was designed to protect religious minorities. What we saw evolve starting in 2010, 2012, 2013 was a shift in what is discrimination and who is the wronged party. And so as I think LGBTQ rights began to gain broader social acceptance, as we got marriage equality, all of a sudden, I think there was a real big effort to translate religious people that disagree with same-sex marriage. They are the wronged party. They are the folks facing discrimination. And we saw a lot of state level RFRAs pop up in areas like Arizona that, you know, the RFRAs popped up in response to cases around public accommodation and same-sex marriage. So, for example, the Elaine photography case, which a photographer challenged the requirement that they serve LGBTQ people and same-sex couples. So what we really saw in 2012, 2013, 2014 was that the bipartisan effort that we saw in the 1990s around RFRA really disintegrated. It became much more conservative focus and much more about protecting the rights of more, I think, religious people's right to deny services as opposed to what we traditionally see as an exercise of belief. These bills are also different because they actually include pretty controversial pieces like a private right to sue, or a lot of the proponents, for example, of the Indiana RFRA actually advertised that this would be your right to discriminate. This will mean you don't have to serve the same-sex couple. This will mean you don't have to welcome an LGBTQ customer into your restaurant. What's interesting, and I think goes to why maybe we've seen these types of bills fade in and be sort of exchanged for things like First Amendment Defense Act and other things like that, is that in a large part of the country, LGBTQ people aren't protected anyway. Until we got the Bostock decision this year, it was actually arguably, as far as explicit protections, legal to discriminate in a lot of these states, in Indiana, for example, especially under public accommodations. And so I think that there was a movement away from these more symbolic RFRAs toward a concern around making sure that organizations could retain taxpayer funding, et cetera.
Thanks, Robin. I think that it's such an important time in the shift in RFRA in those state bills, because it really shows how the rhetoric, right, like changed from we're protecting religious freedom to we need to pass these bills so that we can discriminate against LGBTQ people who are now gaining rights and protections. So I feel like that's when George Stephanopoulos was doing interviews of then Governor Pence and asking him, like, are you saying that this allows discrimination? And he couldn't say no, right? Because that was the purpose of the bill.
One of my favorite interviews is George Stephanopoulos asking him over and over and over and over again. And I think one of the things is that then Governor Pence was absolutely taken aback that this was getting such sort of opposition, because he really was pushing, well, this is exactly like federal RFRA, when it was actually very different. And I think, again, 20 years later, you look at the different civil rights that are on the table, I think he definitely was stunned.
Yeah.
I encourage viewing that interview.
Yes. So RFRA is starting to be seen differently. And Layla, can you talk about one of the most obvious examples of how RFRA has done, which is the Hobby Lobby decision? And that is where RFRA is started to really being used by even in the courts the wrong way. So can you tell us about the case and how it's been used to cause harm in that case?
Yeah, thanks, Maggie. Thanks for having me on this panel. I first want to just take a moment to just recognize and acknowledge what's happening in our country right now as the date of recording. Our Black community is feeling a lot of pain and suffering right now in the midst of continued police brutality and white supremacy. And they and other communities of color are still facing unequal, disproportionate impact by the pandemic, facing greater death, sickness, job loss. These are not normal times. They're actually incredibly tough, disproportionately for those in the Black, Indigenous, and other communities of color. So in recognizing that, I'm connecting it to this panel because we know that when you talk about Hobby Lobby and refusals of healthcare or coverage, as in the case of Hobby Lobby that dealt with the birth control benefit, those tend to fall harder on those who already are facing barriers in life. People who are in low income jobs, thinking about the nursing home aides, the janitors at the hospitals and schools, low income workers, essential workers, and a lot of them work at entities that object to that asserted objections to the birth control benefit of the Affordable Care Act, the ACA. So the Hobby Lobby decision was really the first time the birth control benefit went up to the Supreme Court, and there it was a for-profit billionaire family that objected to the ACA requirement that health insurance plans comprehensively cover contraception, all FDA-approved methods without copay. What's interesting is that, you know, before then, I remember researching case laws on RFRA, and there really wasn't much, right? There was a few, but there was few in between. And then you now do a search for RFRA post Hobby Lobby and look for sites to Hobby Lobby, and it really has exploded. So in tandem to the state bills that Robin was just talking about, you really have seen the Trump-Pence administration and individuals and entities and states take RFRA to a new level. And that was really culminated this summer in a decision where the birth control benefit was at the Supreme Court yet again. And while the majority opinion didn't rule on RFRA, when it held that the Trump administration had the authority under the ACA to do these broad birth control rules that allowed virtually any employer to exempt itself from the birth control benefit, Justice Alito wrote an opinion that was quite disturbing, and that he, you know, really is dropping it doesn't matter if there's harm to third parties. So right now, the way the Trump-Pence administration's interpreted really just changed landscape, both legally and politically, about how RFRA is being analyzed. And even Hobby Lobby, Justice Kennedy in his concurrence said that people should still get seamless coverage even as you acknowledge employer objections. And now you're getting this refrain where you don't even have to worry about that. And the Trump-Pence administration certainly has not. So that, as I mentioned, it impacts whenever you have refusals or the weaponizing of RFRA, it's those people who are already facing barriers that are most harmed. And we're really seeing that across the board.
Thanks. So now we have it being used, advertised to be used to discriminate against LGBTQ people. We have it being used to deny the birth control benefit, so it's affecting healthcare. Katie, the Trump administration has gone all in on this interpretation of RFRA, that it, you know, burdens you don't have to have that strong of a burden on you. Can you tell us a little bit about how they've been implementing this throughout the federal government, to give us sort of a feel of like the reach of RFRA and what it means for it to be misused?
Sure, absolutely. So I think that, as you said, Maggie, and building on Layla's comments, we're seeing a real transition around the time of Hobby Lobby, and as the Trump administration came into office and began outlining their agenda, particularly in this area of how to redefine and utilize religious freedom and RFRA into away from kind of this personal protective statute that was really situationally specific, that looked at the personal impositions of the person who was claiming that their religious freedom was being infringed on, into an exercise of power. And so perhaps the clearest kind of codification of this agenda actually came from then Attorney General Jeff Sessions, who in late 2017, after President Trump signed an executive order urging the administrative agencies to prioritize and strengthen religious freedom protections, Jeff Sessions issued a memo that laid out exactly what that quote unquote should look like within federal government operations. And there we see, building on the Hobby Lobby decision, the idea that RFRA not just protects individuals, but protects organizations, faith-based businesses, for-profit businesses, even. And in each of those situations, particularly as we're getting closer to this idea of for-profit businesses, we're talking about employers with a lot of power over their employees who are seeking to, through a religious exemption, impose their beliefs around, say, healthcare or sexual orientation, relationships onto their employees, well beyond this kind of personal belief that is still very much protected, into what has been called by Justice Gorsuch as defining RFRA as a super statute. This idea that a religious freedom claim supersedes personal healthcare decisions, civil rights protections for those who are then being subject to that so-called third-party harm. So the agencies took this memo from Jeff Sessions, and in many ways they ran with it and began implementing it and developing rules and guidance for how to codify RFRA into this super statute. So for instance, the Department of Health and Human Services has been a real hub for this sort of activity, in particular the Office for Civil Rights, which is tasked with protecting civil rights within the healthcare space, protecting privacy in healthcare. In implementing this memo, the Office for Civil Rights actually rescinded a lot of the healthcare civil rights protections that had been enacted under the previous administration as part of the Affordable Care Act, and dramatically expanded the rights of faith-based healthcare providers and individual healthcare workers to deny care, deny treatment to those in need, citing RFRA. So of course, what happens to that patient who is really in need of care or is looking for a supportive and affirming provider? They're forced to go elsewhere. So they are the ones who will be suffering the harm of that religious freedom exemption. We also see this happening, for instance, in the Department of Labor, which issued a rule that would allow federal contractors to discriminate if they are a faith-based entity. So we're seeing, again, the use of taxpayer dollars in particular being used to implement this understanding and reinterpretation of RFRA as a means to discriminate. Not too long ago, just a few weeks ago, we're even seeing the Department of Housing and Urban Development propose a rule that would allow shelters that take taxpayer dollars to turn away LGBTQ people, particularly trans people, particularly trans women, and use religious freedom, and particularly citing RFRA as a means to create barriers between those who are in need of social services and perhaps very acutely as they are seeking shelter to be turned away under the guise of religious freedom. So we've gotten so far beyond what RFRA was originally designed to do, and this idea that it is a shield for personal belief, not a sword to cause harm to others. And there's a real need for a corrective through the Juneau Harm Act to fix some of the damage that's been done.
Thank you, Katie. Robin, Katie mentioned employment discrimination in the Department of Labor. And employment discrimination in the name of RFRA really started during the Bush era and is now being used even more by the Trump administration. Can you go a little further into the employment discrimination, the taxpayer-funded employment discrimination issue?
Yeah, absolutely. So we first did see sort of percolating employment discrimination around 2004, but it was really concretized in 2007 in an Office of Legal Counsel memo that was requested by World Vision, which if you're familiar with World Vision, it's an organization, it's a huge billion-dollar organization that provides humanitarian aid and does amazing poverty work. And they also, in 2007, were running a program domestically for at-risk youth. And they received a grant under the Juvenile Justice Delinquency Prevention Act, JJDPA. And part of the JJDPA was a requirement that grantees not discriminate on across a myriad of factors, including religion, sex, race, etc. And what's important to note here is that Title VII employment discrimination, clearly you have those built-in exemptions that religious employers can use. there wasn't a co-religionist exemption built into the JJDPA, meaning that World Vision should have been bound by the non-discrimination provision. And to be a co-religionist means that the organization has determined sort of who is a practitioner of their faith, who sort of meets their requirements. And so World Vision argued that in order to receive this federal funding under the JJDPA, they would have to surrender their right to discriminate on the basis of religion in the context of employment. And they argued that this was a substantial burden under RFRA, and they challenged it. And the 2007 Bush DOJ agreed. And the opinion that they wrote in 2007 really interestingly spends pages and pages and pages getting at that this is a substantial burden on World Vision. And it spends about 2 pages on the compelling interest component. And this idea that if something substantially burdens your religion, the government can still make you do it if they have a compelling government interest, and it's the least restrictive means to do it. And so what the 2007 OLC did was really not engage those other pieces. They really just engaged, yes, this clearly substantially burdens you, that you would have to hire someone who was a co-religionist. And I think it's important to note what a co-religionist really is. What does this mean? And although World Vision, it's a Christian organization, I think that you could say, well, co-religionist means that you are allowed to only hire Christians. The thing is that World Vision and all of these other organizations with a co-religionist exemption get to decide who is a Christian, and is able to often link conduct, so for example, or identity. So if you're in a same-sex marriage, for example, you might not meet the standard of Christian that World Vision has set out. And World Vision, after this 2007 opinion, did go ahead and confirm that they mean no matter what kind of Christian you are, and no matter who you think you are as a Christian, if you were in a same-sex marriage, you are not a co-religionist for purposes of World Vision, and they can discriminate against you. And although this seems narrow, only World Vision, only JJDPA, it's not. We saw this applied throughout the past, 13 years. Even in 2014, in the context of a VAWA grant, for example, is explicitly linking this guidance to allowing grantees to discriminate in the context of employment. And what's important here is that it's not, these exemptions don't exist in grant making usually because they're taxpayer funded programs. We really do see that the federal government and taxpayers should have a right to hold grantees accountable and to a certain standard. And what this does, it really eats away at that. This has now, in addition to being used in the context of employment, what we've seen with the Trump administration is also getting at beneficiary rights. And what we saw was in 2019, the revisions to the HHS grant regulation that the Trump administration cites RFRA as a reason, I think what Katie was mentioning around HUD and emergency shelter access, to not even necessarily fulfill the obligations of the grant, which would be serving everyone that is eligible that comes to you, if that type of person, if serving that type of person would burden your religious belief. So we really have seen it absolutely explode across since 2007. And I know that a lot of us are hoping to see that clarified to reflect sort of a more modern legal thinking around employment discrimination and federal funding.
Thanks. So I'm going to keep sort of showing how we're building here, right? So we've got state RFRAs used to undermine non-discrimination laws for LGBTQ people. We've got RFRA used in a Supreme Court decision to undermine access to health care. Katie's talking about how we have now, memos and all these mechanisms in the Trump administration to sort of make this problematic understanding of RFRA affect all of our laws. We have the use of this to say that taxpayer-funded jobs can have a religious litmus test, and that we're going to give money to a religious organization and they can say, here's who we will and won't hire with your taxpayer dollars. So these are all the ways that RFRA is being used. And then, Robin, you mentioned sort of like, now it can be used about who do we want to serve, who do we want to work with? And that takes me to a question for you, Maggie. We represent Amy Madonna, who actually is participating in the National Advocacy Summit. And she's a Catholic mother of 3 who was turned away from a state and federally funded foster care agency because she's the wrong religion. Because she's Catholic and the main taxpayer-funded foster care agency is evangelical Christian, and she could not sign their religious litmus test. Rather than stop this discrimination, Trump exempted the agency from non-discrimination laws. So Maggie, can you tell us a little bit more about how RFRA is being used in this context in foster care?
Yeah, absolutely. And I think the example you just raised about Amy Madonna is particularly helpful in illustrating the issue here, because that foster care agency entered into a voluntary contract with the government and was entrusted with the care of a sizable portion of South Carolina's foster children to help place them in loving homes. So they were performing a service on behalf of the government, and then with all of those children in their care, essentially said, if you're the wrong religion, then you cannot adopt children in South Carolina. And that to me is such a clear example of how these religious exemptions are not about protecting religious freedom, because here they are being used instead to discriminate on the basis of religion. So as a violation of religious freedom. And there's another similar case now that is before the US Supreme Court on November 4th, the day after the upcoming election. The court will hear oral arguments in the case of Fulton versus Philadelphia, where Catholic social services did not want to comply with Philadelphia's non-discrimination laws and refused to certify same-sex couples as foster parents. And so the reason why all of this is extremely important to be paying attention to is that if the court rules in favor of the foster care agency, the result, will be incredibly dangerous. It will say that taxpayer-funded adoption and foster care agencies have a license to discriminate against LGBTQ people and others, and will do so under the guise of religious freedom. And one could imagine the implications of this ruling that would extend far beyond foster care as well into other government services. Certainly, as we've all been talking about, there is a great deal of interest in doing that. And so this is an incredible concern to pay attention to what's happening in the foster care arena right now.
Thanks. That takes me back to a question for you, Layla, about the Supreme Court again. So they didn't rule on RFRA this last term, but the justices referenced RFRA in at least 2 cases, an employment discrimination case, an insurance for birth control case. Without going too into depth from those cases, because a lot of our folks are not lawyers on the call, can you tell us what we learned about the court might do next if we don't pass the Juneau Harm Act?
Thanks, Maggie. Yeah, I do think there were some tea leaves that you could read. That there's a threat of further expansion of RFRA, especially where harm to third parties is at risk. When you look at Bostock, and really an incredible decision, Justice Gorsuch did have, Bostock is the case Robin mentioned earlier. It's the case that said that bans on discrimination on the basis of sex, reaches sexual orientation, and gender identity. And Justice Gorsuch wrote the opinion, and he had this brief few paragraphs talking about, well, what happens when there are religious objections to such protections. And he discussed different grounds for entities that could potentially raise objections to such laws, and raised RFRA as one of them, where he declared it a super statute, as Robin mentioned, or maybe it's Katie mentioned. So he gave a nod, but he said, this is not the case, we're going to deal with it. I will remind folks that in Hobby Lobby, once again, Alito, who wrote the opinion in Hobby Lobby, super disturbing, saying that for-profits can exercise religious belief. He did write in his opinion, responding to Justice Ginsburg's dissent, where she said this is really going to open up a minefield. Haha, look how prescient she was. And she said, what about protections against discrimination in employment? And Alito said, oh, but don't worry about ensuring equal opportunity in employment. Banning discrimination is narrowly tailored, and basically saying, don't worry about it. So if you apply that to protections against discrimination in employment and other, that should apply. So if they, follow what they've said before, notably, Alito only mentioned race discrimination as the discrimination he was talking that could be protected and that people could be protected from. The other piece is Justice Alito, who I think has become, you can see the evolution of him becoming more conservative and expanding the scope of RFRA. In the birth control case this summer, which were states challenging the Trump rules, which dramatically expanded the exemptions to the birth control benefit. It basically allowed anybody to opt out. They did not have to rule on RFRA, and yet Alito wrote a very long concurrence talking about how he thought RFRA allowed the rules, and in fact, they were the rules that had to exist under RFRA. So there's just that he also pulled back on, he's saying, is it a compelling interest for the government to ensure that people have seamless access to contraception? Just really like pulling back on the prongs that are very important of compelling interest and least restrictive means, and really just hanging the hat on substantial burden, saying like, we can't assess if it's a substantial burden if they say it is, and da-da-da. So wait to see what happens, but this is where the Juneau Harm Act would really help, because he's getting to the point where you don't have to assess harm to third parties, and Juneau Harm Act is exactly that. It would make the court consider it in a way that somebody's exercise of religious beliefs do not harm others. So it remains to be seen, and who knows, Justice Gorsuch joined Justice Alito's opinion in the birth control case, concurrence, but I think it's going to be, it's up for further consideration. I'm sure the birth control benefit will be back again at the Supreme Court. It's already been 3 times, so it continues.
Thanks. So all of this stuff is happening in the name of religious freedom, right? Like the people who are bringing these cases are saying that they are using RFRA to protect their religious freedom. When you hear the narrative in the press, it is, religious freedom versus who knows how they categorize everything else. Katie, is this really protecting religious freedom? Is this what religious freedom is? Or is this bad for religious freedom?
So there's a lot of misinformation, and unfortunately, we're dealing with this situation as we've laid out up to this point, where there's really a concerted effort to advance this distorted idea of religious freedom that's taking place by, I would say, religious right affiliated litigators and the courts, allies in the Trump administration, and in agencies. And also there's a really, in some ways, unfortunately, very effective messaging campaign that has gone into redefining what religious freedom means and is in the United States. And I think that it's essential, both as folks are thinking about and lobbying around the Juneau Harm Act, and also in our everyday life, how we think about this and how we talk about this, is to bear in mind that the right to religious freedom is fundamental. It's one of the rights enumerated in the First Amendment. And in many ways, it's very personal, that it entitles each of us the right to believe as we choose. And that means to follow the religious tradition of our choice, or to be non-religious, and to not face discrimination or harm on the basis of those beliefs. But to maintain those protections, there's a balance. For me to believe as I choose, that means, Maggie, you believe as you choose, and I can't expect you to follow my religious traditions and practices, and vice versa. And unfortunately, we're seeing an erosion of that boundary. So there's, like I said, some misinformation around what the Juneau Harm Act might do, and other kind of changes and social progress that we've seen that Robin was laying out in terms of changes around marriage equality, around access to reproductive health services. These changes will not require anyone to change their personal religious beliefs. That is constitutionally protected and remains so. Nor would it require any religious institution to participate in a ceremony like a same-sex marriage that their religious doctrine does not sanction. Because again, what's taught in a religious institution and religious communities are separate from government practice. That's kind of the flip side of the separation of church and state principle. But what we're particularly paying attention to and concerned about and looking to address is when religious belief, again, extends beyond that boundary between personal or communal practice and is imposed on others and restricts the rights of others to do the same.
So that takes us, I think, to focus a little bit more on the Juneau Harm Act and what it actually does. Robin, can you walk us through a little bit, sort of an overview of what the Juneau Harm Act does?
Yeah, absolutely. I think as Katie and Layla have said, the Juneau Harm Act really clarifies RFRA in order to restore the original intent of the legislation, which is to safeguard religious minorities from overly intrusive government action. So what RFRA does is the Juneau Harm Act, does is it safeguards really well-settled areas of law that are designed to protect our most vulnerable populations. And, you know, we're not just talking about LGBTQ folks, we're not talking just about trans women of color in the shelter context, we're talking about child labor and child abuse, healthcare access, federal contracts and grants so that your hard-earned tax dollars don't go to somebody who's discriminating, access to government services, which, you know, the government provides billions and billions of dollars to keep people, especially what we are experiencing now with COVID, sort of in their homes or in their apartments or have food on the table. So the Juneau Harm Act really ensures that religious freedom is used to shield to protect the constitutional right to free exercise, but is not used as a sword to discriminate against these vulnerable populations. And I agree that I think that the Juneau Harm Act really restores RFRA to its original intent and protects the populations that unfortunately have sort of been caught in the crosshairs of the moment that we're in.
Thanks. So one thing I've heard from other people is this fear that somehow RFRA negatively affects like existing religious exemptions. It's going to get rid of them. It's going to affect them in some way. Layla, can you sort of explain how the Juneau Harm Act doesn't affect existing religious exemptions and sort of how they interact?
Yeah, the Juneau Harm Act amends RFRA. And so in federal law, there are many religious exemptions. For example, in the Civil Rights Act, there's a religious exemption in Title VII. Those laws are separate and separate federal laws. So amending RFRA would mean that rules and regulations based on RFRA and the claims that people could take, they couldn't under RFRA. But those other religious exemptions that continue to exist in federal law continue to exist in federal law and will, for example, the one in Title VII continue to be the balancing test that's in Title VII continue to take place even if RFRA is amended.
Thanks. Okay, so we've just heard all of the terrible things that RFRA is being used to do, like over and over, employment discrimination, foster care discrimination, in healthcare, and all of these things being used to discriminate against people based on their religion. So Maggie, why are we pushing the Juneau Harm Act rather than just pushing for a full repeal of RFRA?
Yeah, I mean, I think the objective of the Juneau Harm Act is essentially to restore the intent behind RFRA to protect the rights of religious minorities. And you know, we do want the right to religious freedom to be accommodated wherever possible. And so I think one of the most compelling examples of where RFRA has been used, I think in according with its original intent, was around religious members, military service members, so for example, Sikhs and Muslims have used RFRA to be exempted from military uniform requirements and to be allowed to keep their religious head coverings, even though the military dress code would typically prohibit head coverings. So that allows them to be able to participate in in serving within the federal government and being able to practice their religion at the same time. It is something that does not inflict harm upon others for them to be able to do that, but allows them to maintain their religious rights. And similarly, prisoners' rights is another area where RFRA, I believe, has been used on a number of occasions around being able to maintain a dress code in keeping with their religious practice, having rights to have religious texts and other religious objects, to be served food in keeping with dietary requirements, and those sorts of things. So there are positive benefits to this notion behind RFRA, and the idea behind the Juneau Harm Act is just to prevent it from going that extra step of being, as Robin said earlier, used as a sword rather than used as a shield for protection.
Great, thank you. And then Katie, can you tell us a little bit about the coalition behind the Juneau Harm Act, who supports the bill?
Sure. I think in many ways, just the diversity of work and perspective on the panel here is a really good representation of support for the Juneau Harm Act. This bill in many ways brings together folks who come at this, who are seeing the harms that are being done in the name of RFRA, the Religious Freedom Restoration Act, and who are united in our commitment to protect personal belief while also protecting many of the communities that we serve and that we're members of. So there are incredible groups that are doing gender justice work, like the National Women's Law Center. There are groups that are doing work around LGBTQ equality, like HRC. There are separation of church and state groups like AU, secular groups, along with many faith-based groups, not just my own organization, Interfaith Alliance, but groups like the National Council of Churches, the National Council of Jewish Women, the Hindu American Foundation, who come at this from, again, very different kind of perspectives and experiences, but we are joined in our understanding that we have an obligation to protect the civil rights and civil liberties of all of us, and we can only get there if we do it together.
That's great. So that brings us to the end of our discussion on the Juneau Harm Act. So Layla, Katie, Maggie, Robin, thank you so much for participating today. We really, really appreciate your coalition partnership on this and so many other issues, and your leadership and your knowledge of these issues. Thanks also to everyone who's watching the panel. I hope you learned something new about the Juneau Harm Act. And remember that tomorrow, September 15th, starting at 10 a.m. is our National Day of Action, including more than 70 lobby visits with members of Congress. If you have already signed up to lobby tomorrow, you must complete the pre-lobby day checklist before tomorrow morning. That's available in our virtual action center. There will not be time tomorrow to complete it, set aside on our day, so that's why you need to do it now. The training will give you all the tips and knowledge you'll need to feel comfortable in your lobby visit. And again, you didn't need to memorize and rewatch this video before then. I hope you enjoy the rest of your National Advocacy Summit panels and have a great time tomorrow lobbying. Thanks so much.